We're on part 3, the criminal proceedings. So we've talked about the crime, the arrest, and we've talked about a hearing or a preliminary hearing, which remember the grand jury, the indictment can take the place of that. We talked about an arraignment and how arraignments are used. And so remember, at an arraignment, you are in a courtroom. Same thing with the hearing, you're in the courtroom and that happens. So the next thing that we're going to talk about is the T, the trial. So if someone has pled not guilty, we're going to go ahead and go forward with a trial. In a trial, the suspect must be present in the courtroom. There are exceptions that are made, like they can appear virtually, so they could appear on the internet. That does happen, but suspects are to be present in the courtroom. So you're going to have the prosecutor, the defense, the judge, and the jury. So in the trial, what happens is evidence gets presented by the prosecutor. So the prosecutor is going to present all the evidences they have against the defendant. So they got DNA, they got eyewitness testimony, whatever it is that they have, they're going to present it. They've got witnesses that will take the witness stand and they will swear in thanks to the bailiff. So there's a sheriff in the courtroom or the police officer in the courtroom. The bailiff is going to go ahead and make sure all the witnesses are sworn in. They swear them in, and they also make sure there's law and order in the courtroom. Trials are very emotional, so you want to make certain that you do have the law there. So you'll have your prosecutor. They'll present their evidence. The defense or the defense attorney, the lawyer for the defendant, is going to be able to cross-examine witnesses, so they actually get to ask questions, follow-up questions. They get to argue against the evidence that the prosecution has presented. So they can also call their witnesses. So you don't have to, but if you're on the defense, you are always welcome to present evidence and eyewitness testimony, whatever. You have your opportunity to present valid legal evidence as well in defense of yourself. You don't have to, but you can. What this is the whole time is someone presenting a case. The prosecutor, the government, has to present that the defendant is guilty beyond reasonable doubt. Like, this person did it, there's no question, and you have to convince all the jurors present. So the entire jury is always going to be present in the courtroom during these trials in a superior court, and they're going to determine, they're going to sit in judgment, did this person really do this? If there is no jury, like in a district court in the state of North Carolina, you would just have the judge. The judge would be present the whole time, but the judge would be making the decision on whether the person's guilty or not. Judges are always present in a courtroom, and they act as the referee in the courtroom. So they're going to make sure that the prosecutor and the defense play fair, that the prosecuting attorney and the defense attorney are playing by the same legal book. Okay, so there's rules for the court. You can't just, randomly shout out stuff. You can't just, oh, and this evidence piece, there's no surprises in a court. Pretty much most things are pretty routine in a court. If the defense has a piece of evidence, they really do have to share that information with the prosecutor. Same thing with the prosecutor. The prosecutor's got to share information with the defense attorney. Now, they don't have to share great depths, but they do have to share, okay? So if the prosecutor's got a witness that's going to place the person at the scene of the crime, then the defense attorney needs to know that so that they can be prepared to ask questions of that eyewitness. So very routine in the courtroom. Not really as much like what you see with like Hollywood kind of dramas and stuff. Very much a system of how things will flow. And remember, lawyers have licenses to practice in a state or different states. It just depends on the lawyer. Law degrees, you earn them at your college and stuff like that, but you have to take the bar exam, and the bar exam is what's going to get you the law degree. But you have to know the law that you're practicing per the state. So you have to take those individual state exams. So just because someone can practice law in New York doesn't necessarily mean they can practice it in North Carolina. So they have to pass those different state tests so they can know the state law. Okay. So once the prosecution and the defense have done everything that they could do, they feel confident in their case, or they feel like they've presented all the evidence that they can present, they will rest their case. So the prosecutor will rest their case, the defense attorney will rest their case. And what it means is they've done what they're going to be able to do. The judge will then direct the jury, you are to go and you are to think, you are to deliberate about this decision, guilty, not guilty. They're going to direct the jury. They're going to go away. Could be a day, could be longer. It just depends on what the case is as to how long they are thinking about the case and debating it, okay? So the verdict, the V part. The judge has directed the jury and given instructions. When the jury has deliberated, they've talked, they've discussed everything, their job is to come to a unanimous decision. So everybody is supposed to agree. Either the person is guilty or not guilty. If they are guilty, they're going to do the sentencing part next. If they are not guilty, they have been acquitted of the crime, they are free to go. And they're free to go with the apologies of the court, right? So if the jury comes back with a guilty verdict, all the jurors have agreed that this person is guilty. They're going to tell the judge, and the judge is going to do the sentencing phase, okay? Juries recommend, judge is going to do the sentencing phase. If a jury cannot come up with a decision, like they do not agree 100% that this person is guilty or not guilty, we call it a hung jury, or what you could also know as an undecided jury. They couldn't decide. Something wasn't quite right. They felt something didn't go right. It could be just a piece of evidence that they didn't like. It could be that the alibi was, airtight or whatever it was. Something happened that the jury did not like. And so what could occur is that the judge can rule a mistrial. The judge could make the jury go back and see if they could come up with a verdict. But at the end of the day, if the jury decides that they just cannot come up with a ruling, then the judge will declare a mistrial. And what that means is you're not guilty, you're not innocent, you are eligible to have another trial. So the prosecutor can come back after you. When someone is found, because they're not found guilty or not guilty, they have not been found anything, when a mistrial occurs, a prosecutor can tell the defendant, who's now free, they're free to go, I will come back after you. So next time I'm going to sit another jury. I'm going to present this evidence again. I'm going to see if I can get a conviction. Sometimes defendants will take the plea bargain then. Sometimes prosecutors won't ever go back after the person. It just depends. It depends on what they think. So when a jury comes back and it's a hung jury, if only one of the jurors was like, no, this person's innocent, and everybody else was like, no, this person's guilty, the prosecutor is most likely to tell the defendant, I'm going to come back after you. And if it's only one juror who said this person was innocent, the odds aren't very good in your favor that the next time they sit a jury that they wouldn't be able to get a conviction. So a lot of times people who have hung juries, they will take the plea bargain. They'll take the prosecutor's deal. And then sometimes the prosecutors do. They go through a whole trial with the person because the person won't take it. It just depends on the defendant, the person. If the person is guilty, we move on to sentencing. Not guilty, they're free to go. Apologies of the court. In sentencing, the judge is going to hand down the sentence. That's the punishment. Sentencing is based on the law and mandatory sentencing laws. So, in our country, we do not allow cruel and unusual punishment. The punishment must fit the crime. The fine, the bail, all of it's got to be reasonable. So, like, we have a lot of constitutional rights. When the punishment must fit the crime, you cannot give somebody the death penalty for like breaking and entering. And remember, we talked about that in class. You know, someone was breaking and entering down there in Georgia. You know, the gun went off, the homeowner was killed, but you cannot give the death penalty for breaking and entering, which is what he was given the death penalty for. Instead, what you can give the death penalty for would be like murder, and only first degree murder. Okay, so not manslaughter, nothing like that. You could give death penalty for first degree murder cases. So punishments always have to fit the crime. And so judges do have like, okay, here's what breaking and entering is. Here's some possible like punishments for it, and they have to kind of pick from that menu of options. They're not allowed to just randomly assign things. Like they can't say, okay, you know, because you're breaking and entering, we're going to make you break rocks since you like to break things. So here is, you know, a quarry of rocks, and you're just going to break them from now to the day you pass out. Okay, it doesn't work that way. So judges are very limited on sentencing. And sentencing does get based on what happened and priors. So what we call people who are repeat offenders is recidivists. So they have committed crime after crime and they've been convicted. Okay, so you're only a criminal if you've been convicted of it. Other than that, you're just an ordinary citizen. Once sentencing has occurred, that's when the punishment is going to be implemented. Okay, so if they're giving somebody community service, they will tell you, here's a list of places that you can go to and you can volunteer. You have to sign in at these places and you have till this date to complete your hours. If it's going to be house arrest, they're going to assign you an officer that will check in on you. They will tell you the rules for that, but it might not occur the day of the sentencing. They will tell you, hey, you're going to have house arrest. And then in the next couple of weeks, they're going to let you know, here are the rules for your confinement. Here are the rules for your probation. So that it's not always going to be exactly that day. They sometimes have to make sure rules are very clear and easy for people to follow. And your lawyer can argue back with, hey, you know, this person has to work, so can we let them get to their job every single day and they'll be home at this time? So you do have the right to ask for more or ask for like some differences in it, okay? You can appeal your decision. So after the case is done, the accused, who is now the convicted, so the person who has been convicted, the guilty, has the right to appeal the decision and the punishment. If they felt that the judge handed down too harsh of a sentence, they could get an appeals court to review the case to see if that's true. If they feel evidence was presented that was not allowed, that it was illegally obtained, or the evidence was shaky, maybe there was some evidence that got tampered with, they could ask for an appeal. And an appeal court, remember, reviews the legal proceedings to see if they are fair or not fair. Hope this helped you understand the criminal justice system. And I'm telling you that this is a very simplified version of it.